Chapter 3, Federalism. Remember, girls, that these podcasts are meant as a general overview. They are not meant to be a replacement for you taking notes and reading the chapters. First, we'll talk about the AP focus. An important theme is how federalism has shifted over time. You need to understand the development of cooperative federalism, that's the marble cake, the shift towards devolution, and the most recent shift back toward national power. You need to be aware of the McCulloch versus Maryland case, the Gibbons versus Ogden case, and the U.S. v. Lopez case. They are all important cases involving federalism. You also need to know constitutional clauses that address federalism, full faith and credit, privileges and immunities, and extradition. You need to remember that federalism is a relatively rare form of government. By comparing it with unitary systems, you will understand its advantages and drawbacks. Types of grants have appeared often in released AP exams. You need to know the difference between a categorical and a block grant. One way to study this is through the change in welfare from a formula grant to a block grant. It is in your text in the chapter. Unfunded mandates are important, like the No Child Left Behind Act. Also, the Americans with Disabilities Act has appeared on the exam. Federal grants often contain conditions of aid. The best example is the drinking age. Raising the drinking age to 21 became a condition for states to receive full highway funding. Look at the pros and cons of using federal money to influence policies that have traditionally been left to the states. Hot issues fall in this area: gay marriage, minimum wage, eminent domain, and the Affordable Care Act, health insurance, or Medicare and Medicaid are all federalism issues. Also, you need to see the daily impact of federalism. For example, federal education laws, like I mentioned before, No Child Left Behind, have affected the state and your school. Many proposals have been made to toughen graduation standards nationwide. The Common Core has been set up for math and English at this point in time. Is federalism necessary? Some people believe that unitary systems of government are more effective than federal systems. You need to look at advantages and disadvantages. Okay. As a general introduction, and as a general overview, okay, how one evaluates federalism depends in large part on the value one attaches to the competing criteria of equality and participation. Federalism means that citizens living in different parts of the country may be treated differently. This applies not only to spending programs such as welfare, but also to legal systems where civil rights may be differentially protected or criminal sentencing may vary. Yet federalism also means that citizens have more opportunities to participate in decision-making. It allows people to influence what is taught in the schools and to decide where highways and other government projects will be built. Indeed, differences in public policy, that is unequal treatment, are largely the result of wider participation in decision-making. It is difficult, perhaps even impossible, to have more of one of these values without having less of the other. States participate actively both in determining national policy and in administering national programs. Moreover, they reserve to themselves or to localities within them important powers over such public services as schooling and law enforcement and such important public decisions as land use. In a unitary system, these powers are exercised by the national government. From the 1930s to the present, United States politics and public policy became decidedly more nationalized. with the federal government and especially the federal courts imposing increasingly uniform standards on the states. These usually took the form of mandates and conditions of aid. Begun in the 1960s and 70s, efforts to reverse this trend by shifting to revenue sharing and block grants were only partially successful. In the mid-1990s, the Supreme Court began to review the doctrine of state sovereignty, and the effort to devolve power from Washington to the states gained momentum. Yet the overall impact of these efforts appears to be minimal. Federal spending on social programs, adjusted for inflation, is at its highest level since World War II, and congressional control over spending programs has prompted more regulation of state and local government. The founders disagreed over the exact division of powers in a federal system. Hamilton argued for national supremacy, Jefferson for states' rights. The 10th Amendment spelled out what all the founders assumed from the outset, that the federal government would have only those powers given to it by the Constitution. On the other hand, the elastic language of Article 1, the Necessary and Proper Clause, provided a basis for arguing that the federal government had much broader powers. The rules about who governs what were not clear from the start. The Supreme Court became the arbiter of this dispute. Chief Justice John Marshall supported the Hamiltonian position, and in McCulloch v. Maryland, the court held not only that the Congress had the right to set up a bank, but also that such an enterprise was immune to state taxation. After the Civil War, conflict focused on the Commerce Clause and the power of the federal government to regulate commerce. At first, the court distinguished between interstate commerce, which the federal government could regulate, and intrastate commerce, which it could not. Refer yourself to the Gibbons v. Ogden case. Practical difficulties in differentiating one from the other led the court by the 1940s to hold that the federal government could regulate virtually any economic transaction it wanted to regulate. The Supreme Court's struggles with defining the scope of federal power were influenced largely by economic theory. Under the laissez-faire beliefs that dominated 19th century United States politics, the government was to remain neutral toward the economy and not become involved in its management. The court infused this concept into its decisions on federalism by striking down most government efforts to intervene in the economy. The Great Depression of 1929 compelled the federal government, under President Franklin Delano Roosevelt's New Deal, to take steps to alleviate the people's misery, but the justices consistently voided most such legislation as exceeding federal authority. On re-election in 1936, an exasperated Roosevelt sought to increase the membership on the Supreme Court by packing it with justices who favored his perspective on federalism. Although the court-packing plan failed, one justice altered his view and began to uphold an expanded federal role in the economy. This has been described as the switch in time that saved 9. Recently, however, the Supreme Court has placed some limitations on the ability of the federal government to legislate requirements for the state. In both U.S. v. Lopez, 1995, and Prince v. the United States, 1997, the Supreme Court ruled that the Congress has overextended the Commerce Clause in its regulations on gun ownership. In addition to these rulings on the 10th Amendment, the Court has also upheld state sovereignty through the 11th Amendment, protecting states against suits by residents of other states and citizens of other countries. These cases are a significant development in the Court's thinking about state sovereignty. However, their significance should not be overstated. Though the states are protected by the Constitution, Congress can still legislate extensively and broadly on domestic policy. Some important questions to ask yourself. Under the Federalist system, States have the great flexibility in their management of crime, education, business, and property. What are the advantages of having each state be responsible for these key policy areas? What are the disadvantages? Does the state's growing dependence on Washington have any bearing on lawmakers' relationships with the people? Are people today more or less likely to hold state officials responsible for social problems? Certain areas in Nevada permit prostitution. 9 states have legalized the use of marijuana for medical purposes. One state has legalized it for recreational purposes. Massachusetts and Iowa have legalized same-sex marriage, along with some other states. Could the federal government legally intervene to forbid such practices in these states? Explain why or why not. It would be possible to write a constitution that specified national, state, and even local spheres of governing much more clearly than the U.S. Constitution does. What might such a document look like? What would be its advantages and disadvantages? Please make sure you're aware of the definition of nullification. All right, it's very important that you do understand that. All right, that it was suggested originally by Jefferson and Madison that if a state opposed a law passed by the national government, that the states had the right to declare the law null and void. That was in reference to laws that punished newspaper editors that published stories that were critical of the federal government. The doctrine was then again revived by Calhoun in opposition to a tariff enacted by the feds and later to federal efforts to restrict slavery. This time, the issue was settled by war. At the present, states cannot declare acts of Congress unconstitutional. That was confirmed by the U.S. Supreme Court. Also remember that the full faith and credit, right here, privileges and immunities, and the extradition clauses, these are great examples of federalism. I also want to make a comment on dual federalism. Dual federalism is the layer cake. Until the 1930s, states and national government largely operated in their own sphere. However, as the Commerce controversy in Gibbons versus Ogden points out, separating national from state jurisdiction isn't always easy. Cooperative federalism is your marble cake. Cooperative federalism remains in place today, started at the time of the Depression and the New Deal, with the national government involved to some extent in virtually all public policy making. The next question is about the governmental structure, and really what we should focus on is federalism, is it good or bad? Which branch of government is really responsible for certain things? For instance, Katrina and Rita in 2005. The federal, state, and local governments were fighting among themselves over everything. Please refer to page 60 in your book. The main first responders, or the ones that came with disaster relief, were actually workers from religious and charitable organizations and not from the government. In these particular situations, FEMA was very inefficient. People have differing attitudes and opinions about federalism. You have two political views that begin at the bottom of 61 in your textbook. All right, please take a look at those. But the exercising of political power is really very important, where it's exercised and who exercises it. People will make use of that power for very different purposes. Okay. Madison's belief was that in a republic, all relevant interests can be heard. I want you to understand that also, because of a federalist system, we have increased political activity. It's the most obvious effect of federalism, the mobilization of political activity. The federal system is a decentralization of authority.